From the National Association of Consumer Bankruptcy Attorneys, this is NACBA Now, with your hosts Gene Melchionne and Jim Haller, discussing bankruptcy law for the busy consumer bankruptcy attorney.
Well, hello, Gene. How are you?
I am me. I'm here.
Good. Wonderful. You look great. Today, we're going to be going through the case law update published on the NACBA website on June 22nd, 2023, and hit the highlights of the cases. This is for all the debtors attorneys out there that need some quick information, and hopefully this catches you on the way to court or on the way to work, and hopefully this will be useful. Please let us know if you suggest have any comments. So, Gene, first one is In re Anderson. It's decided on June 14th, 23. Interesting case. This is a situation where the tax buyer sold their right to enforce a lien to a second tax buyer. The first tax buyer was listed in the plan. The plan paid the tax amount, and the second tax buyer said that they weren't bound by the confirmed plan, and the court came back and said, "Oh, yes, you are." And so it's a good case for situations where we have purchasers of tax buyers' rights. Comments?
Yeah, this is a very simple case. Kevin Gibson from NACBA did a great job with the case. The key to the whole thing is that when there's a tax sale, there's always a right to redeem. And this tax buyer was arguing somehow that right to redeem was cut off, which is just complete and total nonsense. And the court got it completely correct.
Yeah, good. It's a good case. Next case is In re Padillo out of Hawaii, decided June 16th, 23. In this case, there were some post-confirmation services done for the debtor in the amount of $10,864, and the attorneys moved for approval of those fees and asked that they get paid before all other creditors, and the court agreed. The court indicated that the creditor may come back later and say, "Hey, we're not getting paid," but the court found that under the court's rules and under the code, this was an administrative expense and should be paid in full. So interesting case for our members out there who don't get paid in full at the beginning of a case or when their attorney's fees are approved. Comments on this one, Gene?
Again, it's an administrative claim. The code is incredibly clear that those get paid before everybody else. I've had this discussion with my trustees too, and we all come to the same conclusion. Those get paid first before secured, unsecured claims. And in this case, the court got it right. NACBA members, Rick Abelman and Lars Peterson from Hawaii did a great job getting it in writing.
The next case, Turner versus U.S. This is out of North Carolina. The court held that the automatic stay does not bar enforcement of a criminal judgment through restitution provided by the Mandatory Victims Restitution Act. The debtor had operated a chop shop before they filed bankruptcy. There was criminal charges entered against him. Part of the judgment was payment of restitution in the amount of about $335,000, and the debtor filed bankruptcy. The U.S. filed garnishment proceedings, and the court said, nope, the government can do that.
Again, the statute, the court hung it on the statute dealing with restitution, says there's no exceptions for bankruptcy in that statute. So they found that preempted anything dealing with the bankruptcy court and the automatic stay. I tend to agree. I was part of a case many years ago that went to the Supreme Court regarding non-dischargeability of restitution orders. And so I know that this is something that the courts take seriously. So Again, a predictable result, in my opinion.
Another interesting case, Henry Hill decided out of bankruptcy court in Alabama, May 30th, 23. This was a very interesting case. The debtor had been injured post-petition in a Chapter 13 and was entitled to a personal injury settlement. And the trustee argued that that settlement should come into the bankruptcy estate and increase the dividend to be paid to unsecured creditors. And the court said, well, they are property of the estate, but they're assets. But an interesting twist, the court said that they should not, number one, they should not be included in the liquidation analysis under 1325A4. The trustee filed a motion to modify under 1329 because A4 is limited to the assets the debtor had when the bankruptcy was filed. And this is a post-petition asset. Also, on the ability to pay standard, which is usually what I see the courts use when they say, well, the debtor has this extra income. And so part of the deal is if your financial situation improves, you have to increase how much you have to pay. The court made a special characterization for personal injury proceeds and basically held that the debtor had earned those proceeds and earned to keep them separate because they paid for it with their injury. So I found it very interesting that the court set aside and allowed the debtor to hang on to the PI proceeds when other things like lottery winnings or inheritances or other things that are quote unquote windfalls, the court said this is not necessarily a windfall because the debtor was injured. This isn't something he got for free. It hurt. So any comments on that?
I had a hard time wrapping my head around this case because it's property of the estate. Apparently the settlement was non-exempt part of it. And so it came into the estate. The court agreed that it was part of the estate, but at the same time determined that it was an asset and not income. And so it didn't need to be devoted to the plan. And that kind of took me a little while to digest because it would seem to me there shouldn't be much of a difference. If it's a non-exempt asset, it's part of the estate, it should be liquidated. So I'm not sure I totally get it. I really need to read the decision in full, which I didn't get a chance to do, unfortunately, but it's a complicated case that I think would be good to read in full.
Yeah, the court said the situation might be different if a debtor receives large punitive damages or an outside jury award, but receiving only a portion of what is supposed to represent compensation for an injury is not a windfall by any means. So
yeah,
it's good.
I got to look at the facts on that one a little closer.
Next case is Inri Baum. Interesting case out of the Eastern District of Michigan. The court was asked to certify a case for direct appeal to the Sixth Circuit, but the court said it couldn't because the notice of appeal was just for the opinion written in the bankruptcy court and not for the actual order entered in the bankruptcy court. So, quick rule of thumb, if you're going to appeal, you want to appeal the order and also the opinion, not just the opinion.
Crazy.
Yeah.
I didn't see much difference in that one, but it makes sense when you get into the details. You have to be careful with appeals. I hate appeals.
Yes. Inri Fierro is the next and last case decided on June 20th out of Georgia, bankruptcy court in Georgia. And in this situation, the debtor was arguing that he'd received his discharge. He was still listed as a defendant in a state court case, and they were still seeking discovery from him with documents and also testimony. And the court said they can do that. As long as you're a nominal defendant, they're not collecting anything from you, then the discharge doesn't prevent the debtor from testifying or producing documents or as a witness. And just an important clarification when we talk to our clients about what's this discharge going to do. Now, I think that the plaintiff may be playing kind of they may be on the razor's edge here, because it doesn't take much to go for it to appear that it's actually collecting against the debtor personally. But at least in this order, the judge allowed it.
And this is a situation that I think is fairly common. I come across it all the time. And it's usually in result to car accidents where there's insurance. And sure, you're going to file the lawsuit nominally against the driver or the owner of the vehicle, but the claim isn't against that person personally. It's against the insurance company so they can collect on the policy. So there's a distinction there, but you have to be very careful in making sure that's reinforced, that it's not against the debtor in violation of the discharge, but rather against the third party.
Yeah. Well, that's all we have for this week. We'll be back next week with a recap of the cases, and we hope to see you soon. Jane, until then, take care.
Okay. Thank you. We'll see you.
Thank you for listening to NACBA Now and your continued support of NACBA. You can find additional materials to assist you on the member dashboard page at NACBA.org. Educate, advocate, litigate. NACBA.